early withdrawal penalties on retirement accounts. And this is probably especially pertinent to those cases that are currently going through a negotiation in terms of coming to an agreement on a marital settlement agreement and how that might impact that. Janelle, do you want to take the first stab at this as it relates to Wisconsin? Then Katie, I'll go to you and you can speak to it as it relates to Illinois.
Absolutely. First and foremost, if you're pending your initial divorce proceedings, understand that the courts maintain all jurisdiction over retirement accounts and other marital assets. So in order to liquidate anything, you first need to have permission and written consent from the other party or a court directive. You cannot do this unilaterally, even though the federal government has enacted legislation that allows for it. So make sure that you're going through the proper means and not start pulling out that money. Even if it is agreed to or directed by the court that you can access those funds, you need to understand that that is an advance distribution of your portion of the marital estate. And so that will count in your column when we're trying to figure out final property division issues. You also need to understand that those distributions are still considered income. And so there is a taxable event to that extent on your income taxes, even if you are not taxed or penalized for that early withdrawal under the federal stimulus. You also need to recognize that under the federal stimulus, there is a payback provision that if those monies are redeposited over the next 3 years, then you won't have a taxable event even for your income taxes. So be mindful of those provisions as you plan, not only for your immediate financial future, but for your long-term future, because the growth on those investments obviously cease once you withdraw that money. And then as you're paying it back, if you choose to do, then you're not being penalized in terms of income taxes that might accrue. But as a post-judgment issue, obviously, if you've already been assigned that as a property division and you have the legal right to access that account, yes, you can take up to that amount from under the federal stimulus without penalty. Again, that still is income taxed. It's still income that you would report for that tax year if you don't end up fully paying that back in that 3-year period. So one of the questions that we run into is, does that affect anything in terms of my reportable income for child support or maintenance? The short answer is that it can. Generally speaking, this provision is meant to accommodate people who have suffered a job loss. And so my expectation would be that people that are accessing it for this purpose are doing so to supplement the income that they're losing. And so there wouldn't be a substantial change in their income for maintenance or child support. But if you are doing it just to take advantage of the fact that you can liquidate an asset without incurring a penalty right now, then you need to understand that if you still have your full-time employment income, then yes, there's going to be a taxable event. You're going to have an uptick on your reported income this year, and that could affect your maintenance or child support calculations. Certainly, if that were my client, I would explain the circumstances, and I would argue around the fact that this isn't a long-term change. It was a short-term one-off payment and distribution, and because it was from a property division of what I suspect to be a final divorce judgment previously, that it's not anything that should offset or be subject to a modification for maintenance and child support.
Awesome. If anyone in our audience,
real quick, if you don't mind here, I think, Janelle, you made some great points and you clarified it really, really nicely. I think it's also important to recognize too that in order to qualify for the withdrawal without having the 10% penalty, you need to be able to demonstrate a financial hardship. And some of the factors or the reasons to be considered are if you and your spouse have been diagnosed with COVID-19, if you are quarantined, furloughed, or laid off due to COVID-19, if you're unable to work because of lack of childcare, or if you've had to close or reduce hours of a business as a result of the virus. Those are all things that they're going to look at to determine if you qualify for financial hardship. So I guess it can't just be anybody who can withdraw from their retirements or IRAs without the 10% penalty. You do have to experience a financial hardship. And as Janelle stated, that you do have that 3-year payback period. And along with that includes the when the taxes would be due. So the package is stating that you don't have to pay the taxes though for those 3 years. So giving those people the opportunity to pay that money back before ever having to actually pay the taxes on it. So something to advise our clients of is that if you qualify for financial hardship and therefore you no longer have to worry about the penalty, you do have 3 years to pay it back, but you also have 3 years to pay the taxes. So to make sure we consider that when making those decisions.
Divorce order was already put into place, but the the retirement accounts were not yet split. And what might happen if someone leverages this scenario to access those funds when they shouldn't, even though they're the owner of that account? Can someone speak to that?
Sure, Tony, you're absolutely right that is likely to be a contempt issue. Say we just put ink to paper on a judgment of divorce and we haven't gotten around to the qualified domestic relations order that would divide a retirement account, and then someone unilaterally dips into that account to the extent that they have surpassed their ongoing interest in that account. I would suggest to my clients and recommend to my clients that you not take a distribution that exceeds your remainder interest in that account. And as we all know right now, the market is obviously fluctuating severely based upon this crisis. And so what your potential share today is may not be your potential share tomorrow. So you have to be mindful of any distributions that you might be taking when there is a pending division of that asset. So the short answer in my advice would be not to exceed your remaining share in any distributions that you might take, and also consider that what the balance is today may not be the balance tomorrow, so adjust accordingly. On top of that, obviously, if that account has been assigned to the other party, you shouldn't be touching it at all. If they've received 100% of an account in your name, but it just hasn't been transferred to them yet, you cannot touch that at all. And the contempt actions that I expect a court would hear and decide are going to include some pretty significant penalties for financial abuse. I mean, that's essentially what it boils down to. You cannot deplete an asset of another party, and as a post-judgment issue, the courts find that to be a very serious and egregious violation, especially when a judgment had just been entered and we haven't been able to effectuate that judgment yet. So not only would you have penalties related to paying back those monies, there could be interest assigned, there could be attorney's fees, and in some drastic situations, contempt actions do incorporate a potential for a jail sentence if you don't comply within a certain period of time. And if your economic circumstances currently aren't providing for you to pay for your own support, I would imagine that you don't have the funds to repay in a quick fashion what the court would order you to do, and it's not worth risking going to jail for.
Katie, anything to add on either the waiver or as it relates to that last question, kind of pending divisions of retirement accounts?
Yeah, I think I just have a couple notes. I mean, I definitely, in terms of advising clients in these types of situations with retirement withdrawals, anything affecting taxes or assets, I always try to include or refer a client to either a financial advisor or also an accountant, because those are going to be the best people in the best position to address and answer any particular questions that our clients may have in terms of tax implications, what they can or can't do under these new regulations. And so I think I would involve maybe some of those professionals as well, or refer our clients to someone who is really specialized in those areas to help. Also, in terms of Janelle's last answer, I 100% agree with her. I also think it all depends on what the judgment and the settlement agreements say. So I know from our firm's perspective, we add in language, particularly that neither party is going to unilaterally do anything to drastically affect the retirement accounts post entry of a divorce. So I actually think that if someone were to unilaterally do something like that, it would be a violation of the language that we include. And I definitely think that a judge would address that accordingly in any type of post-judgment petition for rule to show cause or a petition for indirect civil contempt in Illinois. So I agree with both Rob and Janelle in terms of their analysis thus far, and just have those notes to add.